It is often humored. Where there is a will, there are relatives. But when there is a will, or when there ought to be a will, there are a lot of legal issues that we need to consider, a lot of legal formalities that go into making a will, and a lot of legal terminology that we need to understand while we make our wills. While most people have a fundamental question of whether or not I should make a will, and the other issue is when should I make a will? These are issues that we will discuss at the end while we discuss first what are the essential elements and what goes into making a will. Let us first understand a few of the terms, the technical terms that are used in making of wills. The first and most important term is the testator. The testator, which is used for males, is alternatively used as testatrix for females. This means the person who has made a will. So very simply, the person who makes the will is called a testator or a testatrix. The next is a legatee. Who is a legatee? A legatee is a person who is named under that will to take personal property in the will, or one who receives property under a bequest or a legacy. We then come to the term bequest. What is a bequest? A bequest is property disposed of in a will or by virtue of a will. So every property that is disposed of becomes a bequest. We then come to another term which forms a very important part of a will, the executor. The executor is a person named by the testator in a will to carry out the provisions of the will. In case the person is a female, she will be referred to as an executrix. Let us now understand some of the key elements that go into drafting of a will. What are these key elements that you need to put in to make sure your will is complete, your will is valid? Firstly, the details of the testator or the testatrix, namely the person's name, the person's address, other relevant details of the testator or the testatrix, and of course the religion. Generally, this would read, I name, the name of the person, adult Indian religion of the person, residing at the address of the person, do hereby make this as my last will and testament. This is how your will would generally open. The next paragraph would contain a declaration revoking all previous wills and codicils. Why is this? Because the rule in wills is the last will is the one that is valid. The last will is the one that goes for probate and is finally executed. Therefore, it is very important when you make a will to revoke all previous wills. The next thing that you need to mention is your status or your mental capacity in making that will as a testator or testatrix. You need to state that you are of sound mind and free will and volition while you make this will. This will eliminate any possibility as to anyone raising any questions as to whether or not this will was made while you were not of sound mind to make it, or while you were under undue influence or coercion. You would then like to disclose the members of your family, or what we would call the heirs apparent, persons like your legal heirs in whatever context that may be, who would ordinarily be entitled to receive this property on your death if this will hadn't been made under the law of succession for the time being in force. With that, we move to the core of the will, the crux, the subject matter of the will or the testament. This is the actual part where you make your bequests. Now, this would come into two parts. I would love to divide this into two specific aspects. One is your list of assets and the second is your bequest. So, firstly, you need to list out or enumerate or name the assets, movable property, immovable property, monies, jewelry, shareholdings, if at all, and whatever other assets, tangible or intangible, movable or immovable, you may possess. Now, if this list is long and you do not want to include it as a paragraph in your will, you can annex it at the end of the will as a specific schedule or in multiple schedules. The second part that I spoke about is the bequest, the actual devolution of your property, the way the property devolves to the respective beneficiaries and legatees under that will. So there you will say that this property or the properties contained in Schedule 1 will go to X and the properties contained in Schedule 2 will go to Y. This is how properties could be distributed. There are various ways in distributing this, and in drafting this, you should consult your lawyer as to how you should do this. The next aspect are conditional bequests, where bequests are given under certain conditions or for a limited period of time. The classic case would be a life interest where property would go to a particular person for his lifetime and thereafter to another. Now, as we reach the end of the testament, certain things that you would want to consider. Firstly, the signature of the testator with the date. That is the most obvious thing that everyone would look at. The next is the witnesses. To ensure that your will is valid, you need two independent witnesses. Now, when we say independent witnesses, what we mean is that the witness is not receiving any benefit, is not a legatee, or has no right under any of the bequests contained in that will. In short, the witness should receive absolutely no benefit under that will. Now, there is one thing that you need to note when it comes to the witness. This is a question that several people ask us. Does the witness need to know the contents of the will? And the answer to that is no. You need not show the entire text of the will to your witnesses. But you need to remember this. Your witnesses are persons that are attesting the testator's signature. When you say your witnesses are attesting the signature, it means that your witnesses need to be present with you at the time you sign your will. And they need to see you signing that will. The will has to be signed in the presence of both the witnesses. This is extremely crucial, especially when it comes to testamentary suits and probates. Now, while we spoke earlier about being of sound mind, it is imperative that if, especially in cases of senior citizens or in cases where a person is known to be suffering of a prolonged illness, in such cases it is necessary, or at least it is sincerely recommended, that a medical certificate from a doctor is annexed. And this medical certificate needs to be dated as close to the date of the will as possible. Ideally, it should be not more than 3 to 4 days prior to the will. The medical certificate needs to be issued by a registered medical practitioner and needs to certify that that medical practitioner has examined the testator and the testator is mentally of sound mind and in a position to make his will. The last aspect that comes in connection with wills is it necessary to get a will registered? Well, registration of wills is absolutely voluntary. By registering a will, the document has the force of an additional witness in the sub-register or the registering authority. But to answer that question, if your will is not registered, it is as much valid as if it was registered, as long as you have two independent witnesses. And then we go back to where it all started. What is the right time to make the will? When is it appropriate to make the will? And do I need to make a will? A will or a testamentary disposition would obviously make the dealing with of your property post your demise extremely simple and straightforward. So therefore, if you own property, it is always advisable to make a will. And then to answer the other question of when is it the right time? The right time is always now. Therefore, on that note, I leave you with some food for thought. It is imperative that we make a will for each of ourselves. It is imperative, if you do not want your next in kin or your legal heirs to be battling over your property, to dispose of or devolve your property by a will.